Next up, we are going to the Hague Convention again. This is from South Gauteng High Court, and this is quite an interesting judgment under the pen of Crutchfield J. That is on bundle page 197, summary page 14. Central Authority for the Republic of South Africa and another versus M and another ZAGP JHC 458. As in most of the cases where we see the Hague Convention applied, the fulcrum was Article 13b, grave risk of harm under the convention, which is one of the justifications for a child not to be returned to the former country in terms of the Hague Convention. So this was an application by the Central Authority for RSA. Obviously, as we know, this is the family advocate, and the minor child's father seeking the return of the minor child to Australia. The mother opposes the application, citing a grave risk of psychological harm to the child, and the court then addresses whether the child was wrongfully retained and if an exception under Article 13b of the convention applies. Now, we know this happens in the wake of the Constitutional Court judgment where the child was eventually ordered to return to the United Kingdom, preceding of which we had a whole line of cases refusing the return under Article 13b. Now, in this case, the court returned the child, rejecting the Article 13b argument which was put up by the mother. The convention is quite clear. Unless an Article 13b exception, i.e. a grave risk of harm, is established, the child must be returned to the country of their habitual residence, if it is a treaty country, obviously, or a convention country. The burden of proving the Article 13b exception lies with the party opposing the return, in this case, the mother. The mother must prove that there is a grave risk of harm, and the court looks at the threshold. It must be a grave risk of harm. The threshold is very, very high. 117 of the judgment says the threshold for meeting the exception in Article 13b is high. The level of risk alluded to by the respondent in the founding affidavit and the report of Ms. Keeve, who was the expert, does not rise to the standard of a serious nature required by the exception, does not reach the degree of seriousness of risk of harm or the harm itself envisaged in the convention. The emotional harm that is contemplated by the article must rise to the level equivalent to an intolerable situation. The facts and evidence before me do not meet the threshold in terms of Article 13b. Paragraph 118, the very next paragraph. The alleged harm relied upon by the respondent in the event of the return of the minor to Australia is that described by the Constitutional Court in paragraph 63. It is harm that is inherent in the inevitable disruption, uncertainty, and anxiety which follows on an unwelcome return to the jurisdiction of a child's home country. In the circumstances, the alleged risk of harm does not warrant the description of grave risk. And there is no real or grave risk that the minor, upon return to Australia, will be exposed to harm, or that the level of risk is grave. Now, incidentally, we know that there are a lot of forums taking place, notably later this month in Pretoria, the forum on the Hague Convention and obviously protective measures, because we know that in a lot of instances, the Hague Convention has been utilized by spouses or parents in instances where abuse was present. Now, that is going to be very interesting to see the upshot of that. But for now, Central Authority for the RSA and another versus M and another, following the Constitutional Court and Crutchfield J ordering the return of the child to Australia.